Welcome back to the deep dive. Today we are diving headfirst into a source stack that is just incredibly dense, but also kind of electrifying.
It really is. We're looking at a massive legal submission, hundreds and hundreds of pages.
Can't get this. It's filed by one person, a disabled litigant in person, going up against the behemoth that is the Department for Work and Pensions, the DWP.
That's right. And we're not actually looking at the original trial facts today. Our focus is on the roadmap for a very high-stakes remedy and costs hearing. It's scheduled for October 2025.
So our mission is to take this document, which is all about, deep procedural law, and pull out the crucial nuggets. We want to understand the claimant's core argument.
Which seems to be that they were systematically disadvantaged, that there was a kind of systemic abuse of power. It's really a story about procedural warfare between a person and a state institution.
And that power imbalance is everything.
It's the whole game.
Yeah.
You have an individual, a disabled litigant, up against a government department with what seems like, unlimited legal resources.
Yeah.
So the rules become absolutely critical.
Okay, let's unpack this then, because the submission kicks off with a real shock factor.
It does.
The claimant states they're attending this hearing under duress. They say they're medically unfit and are there under formal protest.
And the reason is that they allege the tribunal has ignored multiple requests for reasonable adjustments and, maybe most importantly, a stay on the proceedings.
A stay, so a pause.
Exactly, and that's the first huge objection. The claimant points out that there's a live appeal already lodged with the Employment Appeal Tribunal, the EET, about the original judgment.
So the whole basis of this hearing is still being challenged elsewhere.
Precisely. And they cite Rule 36, which gives the tribunal the explicit authority to just pause everything while that appeal is decided.
So what does that mean in practical terms, to just carry on with a costs hearing when the underlying judgment could be overturned?
Well, it creates this enormous logistical and, frankly, emotional burden, especially for a disabled litigant. The submission notes they made 7 separate requests for a stay. 7, between the 2nd and 19th of October. By ignoring them, the claimant argues they're being forced to prepare for a hearing that could become completely pointless if their appeal succeeds.
And that failure to adjust the pace is framed as discrimination, right?
Yes, under Sections 20 and 21 of the Equality Act. But it's not just the live appeal. The claimant also says the hearing lacks any basic structural integrity.
Because there's no case management order, a CMO.
Exactly. Nothing has been issued since the judgment back in September 2024. And Rule 29 is pretty clear. Tribunals are supposed to issue CMOs to set deadlines, manage evidence, to create a level playing field.
Without one, it just becomes chaotic.
And that chaos, the claimant argues, was leveraged by the respondent.
Right, because the DWP served a huge bundle of evidence. What was it, 450 pages?
450 pages, served just 48 hours before their own deadline.
48 hours, that's just crushing for anyone, let alone a litigant in person who's already asked for adjustments.
It is. And the claimant had repeatedly asked for a 28-day window to review complex documents because of their disability. So this isn't just a scheduling issue. The claimant argues this whole pattern. The ignored stay, no CMO, the late document dump, it's procedural warfare.
And it connects back to earlier issues, doesn't it? The document mentions a strikeout request from June 2024.
It does, alleging persistent noncompliance with disclosure orders going all the way back to 2023.
And there's a really fascinating specific example they use.
The Google Drive incident.
Yes. The DWP's lawyers apparently claimed they couldn't access the claimant's documents, which were shared via Google Drive.
But then, and this is where it gets really interesting, the claimant includes screenshots in the submission.
And what do they show?
They show that access had been granted, and that the DWP's legal team had been able to see those files since 2023.
So this isn't just a technical glitch. It's presented as direct evidence of obstruction.
It's a very specific claim. The claimant argues it's a deliberate tactic to exclude their evidence from the final bundle, which they say is an act of continuing victimization and a breach of the overriding objective of fairness.
So we've got this picture of structural unfairness. But let's shift to the evidence itself. The reason for the dismissal. The claimant argues the whole thing was flawed from the very beginning.
Absolutely. They target what they call a material error of law, and it's all about the reason for dismissal.
There's a contradiction in the judgment.
A direct one. Paragraph 937 says the dismissal was for capability. But if you go back a bit to paragraphs 835 to 840, it records the dismissal was actually for gross misconduct.
And those are very different things.
They are mutually exclusive legal justifications. Gross misconduct implies someone did something wrong intentionally. Capability is about, performance or health. You can't be dismissed for both at the same time for the same reason.
So if the tribunal can't even get the reasons straight,
The claimant argues the entire finding is legally unsafe, even perverse.
and that contradiction then opens up this whole other technical vulnerability in the DWP's case.
It does, and it's centered on the CIS, the Customer Information System. This is the technical flaw that seems to be central to the whole thing.
The argument being that the DWP relied on a policy assertion, not forensic proof.
Exactly. And the weak point comes from an admission by a DWP witness. He confirmed that hybrid workers all connected to the system through a shared DWP IP address.
Wait, a shared IP address. So how can you possibly tell which specific employee on their own device at home did something?
Well, you can't. Not reliably. Not without much deeper forensic data. The claimant's point is that you'd need device logs, session IDs, certificate audit trails, sort of digital fingerprints that tie an action to a specific machine.
And the DWP didn't provide that.
The claimant alleges they refused to obtain or disclose it, even when it was requested. It's like, someone uses the family computer to visit a weird website. You can't just blame the first person you see. You need to know who was logged in.
That makes it so clear. So they're accused of relying on a flimsy assertion instead of hard data.
Precisely. And the claimant argues that going ahead with a dismissal without getting those logs or calling technical witnesses, that falls way outside the virtual standard for a reasonable investigation.
Can you just quickly explain the Birchall standard for us?
Sure. The Birchall test basically asks 3 questions. Did the employer genuinely believe the employee was guilty? Was that belief based on reasonable grounds? And crucially, did they carry out as much investigation as was reasonable?
And the claimant is hitting them on that third point.
Hard. They're saying the DWP skipped the most critical forensic steps. And to make matters worse, they also allege that the DWP produced 3 different inconsistent versions of the CIS report during the proceedings.
So the key piece of evidence was unreliable from the start.
That's the argument. Which really brings us to the next part of the submission, which is about conduct that happened even after the claimant was dismissed.
This is the ongoing victimization claim under Section 27 of the Equality Act.
And it is a very disturbing pivot. The claimant alleges that DWP managers, after she was gone, engaged in covert, unauthorized monitoring of her personal social media.
Including her disability advocacy work, which she calls the Justice Journals.
Right. And she frames this work as a form of rehabilitation offering templates and guidance to other disabled people. The submission includes this really powerful statement to push back on the DWP's defense.
I saw that. It's a direct quote.
Yes, I advocate because I was harmed. I wasn't harmed because I advocate.
Wow. That completely reframes it, doesn't it?
It does. It directly challenges what she claims is the DWP's narrative, that her public activity is some kind of self-inflicted harm designed to inflate her compensation claim.
So they're allegedly monitoring her and then using her own advocacy work against her in the litigation.
The claim is that they're using selective screenshots and even fabricated transcripts of her posts, which she says amounts to ongoing retaliation for bringing the claim in the first place.
And this ties back to one specific manager, Mr. McCartan. The accusation there is extremely serious.
It is. The claimant alleges his evidence was demonstrably false. It's a claim of perjury about his knowledge of her disability. And this alleged bad faith is what she's using to justify seeking aggravated and exemplary damages.
Which are very hard to get.
Incredibly hard. Exemplary damages aren't about compensation. They're meant to punish a respondent for oppressive or unconstitutional actions, especially a state body. The claimant is arguing the DWP's conduct meets that very high bar.
And to really drive that point home, she links her own experience to a much bigger systemic issue.
Yes, this is crucial context. She highlights that the DWP is already under investigation by the Equality and Human Rights Commission, the EHRC.
For its treatment of disabled benefits claimants.
Right. So it reframes her case not as some isolated HR dispute, but as a symptom of a much wider institutional culture of alleged discrimination.
Okay, let's shift gears now to the money. The financial stakes here are just staggering. First, the DWP is asking for costs from the claimant.
They are. They're seeking a costs order for £105,093.78.
Over $100,000 against a single person.
And the claimant is not just pushing back. They are dissecting that bill. They challenge it as completely disproportionate and padded, but it's how they challenge it that's so clever. They point to one specific line item in the DWP's bill.
What is it?
A charge for £1,099, the description. reviewing online content.
No, so that's the surveillance. They're trying to charge her for the time they spent monitoring her online.
That's the argument, that this is a cost incurred for harassment and is therefore completely non-recoverable. They're using the DWP's own bill as evidence of retaliation.
Unbelievable. Now let's flip that and look at the total remedy the claimant is seeking. This is where that 1.7 million figure comes from.
It's actually $1,753,869 to be precise, and it is meticulously broken down.
So what's in there?
There's a huge claim for loss of future earnings, right up to retirement age. That's over £500,000. Then there's an award in the top vento band for injury to feelings.
Which is reserved for the most severe cases of discrimination.
The most severe, long-lasting cases, yes. We're talking about significant mental health impacts. Then you have this massive claim for additional damages.
The punitive ones.
Exactly. A claim for £200,000 in aggravated and exemplary damages to punish the DWP for what the claimant calls high-handed and oppressive conduct.
And finally, there's the damage to her reputation.
This is a really important point. She's demanding either that the judgment is anonymized or she gets another £25,000 in compensation.
Why?
Because she argues the publication of the judgment, which contains what she says are false allegations of data misuse, has permanently destroyed her employability.
So the tribunal's own process is part of the ongoing harm.
It links the failure of due process directly to a future financial loss.
So when you put it all together, a litigant detailing systemic unfairness, a core technical flaw in her dismissal, post-employment surveillance, all culminating in this multi-million-pound claim. Is this, a case of someone exaggerating grievances, or is it a compelling picture of a public body engaged in a serious abusive process?
Well, the submission really forces you to confront the immense burden placed on a litigant in person against an institutional opponent. The claimant's request for the full logs of all DWP monitoring activity under GDPR Article 15 that raises a really profound modern question about the limits of post-employment surveillance by a public employer.
That surveillance question really does cut deep, which leaves us with a final thought for you to mull over. If a government department is already under official investigation by the equality watchdog for its systemic treatment of disabled claimants, how much more scrutiny should apply when that very same department is facing a discrimination claim from its own disabled employee, especially when forensic evidence, procedural conduct, and alleged retaliation are so central to the dispute?